Hi everyone. In this lesson we'll be talking about two main pieces of legislation, which are OSHA and ERISA. OSHA stands for the Occupational Safety and Health Act. This was passed in 1970 and then has had a few amendments over the years. This is the one that regulates workplace health and safety standards. ERISA is the Employee Retirement Income Security Act, passed in 1974, which sets standards for retirement and other employee benefits programs. Okay, so diving right in, we'll start with OSHA. Okay, so again, this is passed in 1970. I give you a couple links here, and this applies throughout the notes. If you have access to my notes, you can just download those, open them, and then these links should work to take you to some deeper learning about whatever we're talking about. You may want to learn about this from the employee side to understand your rights. You might want to understand it from the employer side to make sure that you're complying with the law. Either way, you can learn much, much more. So I'll give you the basics. Okay, so it requires employers to provide a safe and healthy workplace to employees. There are some exceptions, some companies that aren't regulated by OSHA. So these are family members that are employed by family farms, state and local government employees because they're regulated elsewhere, workers in environments covered by other federal agencies. So in the government employees example, there are other regulations in place to provide safe and healthy workplace. For the family members, well, there's just not a whole lot of protection for you there. So in North Carolina, this is run by North Carolina's Occupational Safety and Health Division of the Department of Labor. So within the Department of Labor sits this Occupational Safety and Health Division. States are allowed to have this state plan status. The catch is they have to adopt standards that are, quote, at least as effective as the federal OSHA standards. So yes, while North Carolina runs its own plan as a state plan, we, for the most part, adopt the OSHA standards. And then the federal government provides, I think, about 50% of the funding there. So I'll be flip-flopping between what federal OSHA standards is and what North Carolina specifically says, but for the most part, they should be roughly equivalent. So Section 5A of the federal standard imposes two basic requirements on all employers. There's a compliance requirement saying you have to comply with all the standards dictated by the Department of Labor. There's also the general duty clause, says the employer has to furnish a place of employment free from recognized hazards causing or likely to cause serious harm. Okay, so the basic overall idea is we're trying to provide a workplace that is as safe as can reasonably be provided. And there are some jobs where there's just inherent dangers and we can try to mitigate those, but there's no getting around the fact that there's some danger there. There are a lot of other employer responsibilities. I'll give you a short list that I picked out some of the important ones, and we also have to recognize that there's a lot more to it than that. So I gave you a list to some longer, a little bit of a longer list of standards, and then you can get further into the weeds if you choose to do so. So some other things employers have to do. We have to make sure employees have and use safe tools and equipment and properly maintain this equipment. We have to use color codes, posters, labels, or signs to warn employees of potential hazards so I don't inadvertently get myself into a very dangerous situation. There should be some warning there. I have to establish or update operating procedures and communicate them so that employees follow safety and health requirements. So I have to establish them. I also have to train employees on how to follow those protocols. Employers that have hazardous chemicals in the workplace have to develop and implement a written hazard communication program and train employees on the hazards they are exposed to and proper precautions. And a copy of safety data sheets must be readily available. what we're learning here is that in order to comply with all this, there's a lot of responsibility that falls on the shoulders of the employer. Okay, we have to establish safety standards, we have to communicate them, we have to train employees, we have to make safety data available to employees. So there's a lot going on here. Employers must provide safety training in a language and vocabulary that workers can understand. So we're not encoding it in legalese and technical terms if the employees wouldn't reasonably be able to understand those terms at that time. We have to communicate it in a way they can understand. And there are some reporting requirements here. I have to report work-related injury, illness, or death in within a few different time frames. So if there's a fatality, I have to report to the Department of Labor within 8 hours, so very quickly. Other illnesses and injuries, so within 24 hours, I have to notify if there's any work-related inpatient hospitalization of one or more employees, any work-related amputation, any work-related loss of an eye. So depending on the severity of the injury, then I might have to report quicker. I have to keep records of work-related injuries and illnesses. I have to post OSHA citations at or near the work area involved. So if there's an infraction and OSHA gives me notice of that, then I have to post notice where the infraction happened. So each citation, that's the citation is the notification there. Each citation must remain posted until the violation has been corrected or for 3 working days, whichever is longer. And I have to post abatement verification documents or tags. Abatement just means what did we go in there to fix the issue. So we have to verify that the problem has been abated and then post that verification there. Moving on, we have to correct cited violations by the deadline set in the OSHA citation and submit required abatement verification documentation. So following in the line of logic here, if we find a violation, OSHA will give me this citation. I have to do an abatement to remove, fix whatever the issue is, and then provide documentation that I've actually fixed it. Finally, in my list here, we have to notify workers of their rights. So this is, one of the things we do here is we post this poster that you can get from the Department of Labor that notifies employees of their rights under OSHA. There's a few laws where you have to post this for like FLSA and some others. And these are usually like in work break rooms or something like that. Usually not public facing where the customers aren't seeing it or clients, but usually somewhere where only employees are. And we can usually see these posters that are hung up there, and you can read those and learn more about your rights as an employee. Employees are protected from retaliation from reporting or participating in OSHA notification or investigation. So if I report my employer for violating OSHA standards, I'm supposed to be protected from retaliation. It can get a little bit messy in the real world. My employer might try to find some unrelated reason to try to get rid of me, and I would have to prove that that was just pretext for the retaliation that they're engaging in. But I do have some legal protection there. In North Carolina, we have a separate act called the North Carolina Retaliatory Employment Discrimination Act, or RETA, that provides similar protection. And I linked you to where you can read the act and then just learn more from the Department of Labor. We dig a little bit into history here. So we're just going to sort of look at pre-OSHA, what was happening if somebody got hurt on the job, and then post OSHA, what does it look like here, just to learn a little bit about, our system and why it is the way that it is. So prior to OSHA, if somebody gets hurt on the job, there were employers pushed for laws to be passed that made it very difficult for workers to recover any money for the loss. So they would use laws like contributory negligence, meaning if the employee contributed in any way to their injury, then they could recover nothing. Assumption of the risk, meaning that if I just notify employees of the risk and they choose to take on that risk, then they can't hold me liable for it. And finally, the fellow servant rule, meaning that negligence was the fault of an employee rather than the employer. If we could prove that, then the employer is not liable. So various ways that employers could try to escape liability for somebody getting hurt on the job. Now, they made it so hard that almost nobody could recover. So then this is what led to this reform that we get here with the passage of OSHA. And then we get this no-fault workers' compensation law. And I linked you to the North Carolina Workers' Compensation Act and some coverage requirements there. You can read more. Most employers are going to have to cover their employees for workers' comp. It used to be called workmen's comp. Now we're using more inclusive language. At the heart of it is what we call the compensation bargain, which means that employees get protection from work-related injuries while giving up certain rights to sue. So if I get hurt on the job, rather than suing my employer and trying to get $100 million or whatever, I think I'm entitled to, I will probably have to work through workers' comp first, and that's been highly systematized, and over time we developed even formulas to account for the loss of limbs, eyes, ears, whatever it might be. So while I give up that right to sue in a lot of cases, not always, but in a lot of cases, I have a much better likelihood of recovering something under the workers' comp program. No fault in there, the quote, no fault program, means that employees don't have the legal burden of proving that the employer was at fault. If I'm injured while at work or while doing something that work requires me to do, it's kind of a default assumption that I should be covered. That's not the end of the story, because the employer has ways of proving that it wasn't actually their fault. We'll dig into those defenses a little bit more later. Not every... Whoa, I skipped one. Okay, so this requires most employers to pay for workers' comp insurance. This creates a risk pool, across many different employers, so that one injury doesn't have to result in the complete folding of a business that results in insolvency and bankruptcy and whatever else. So that's the whole idea that insurance works here similarly to everywhere else. If we create a very large risk pool, if a few people get hurt, we can compensate them without sinking the entire business. So not every injury is going to be covered. For example, it usually doesn't cover employees who are under the influence of drugs or alcohol, which is why employees are likely to be drug tested following an injury report. This will be standard protocol in a lot of businesses, maybe even most businesses. If somebody's hurt, obviously the employer is going to not really want to pay for that injury, so they have some defense available. And if they can show that you were intoxicated at the time, then that's a pretty good way for them to escape liability. Okay, the employer will also not be held responsible if it can show that the harm was the result of reckless behavior. Okay, so if I'm driving a forklift and I'm acting responsibly and I get hurt, then I'm probably covered under workers' comp. However, if they find out that I was just trying to show off to all my buddies in the warehouse by showing them what cool tricks I can do, then that really lowers the likelihood that the employer will be responsible, and they will probably escape liability there if I'm acting recklessly. Also, the employer might not be held responsible if it can show that it is physically or economically impossible for the employer to comply with a safety requirement. So we might find that something inherent about this job requires that things be set up the way that they are, and it's just not possible, either physically not possible, or it would just be so expensive that it's just economically impossible for the employer to comply. And then, with that there, we would just have to have proper training and safety awareness to try to mitigate those dangers there. Also might not be held responsible if we can show that complying with the requirement presents a greater harm than not complying. This would be called the greater hazard defense. We're talking about edge cases here. We're looking specifically at some danger. Maybe if I comply with an OSHA regulation, it actually makes the situation more dangerous rather than less. And I would just have to demonstrate to OSHA that that's the case and prove it to them. And then I might not be held responsible as an employer. Finally, in defenses here available to employers, I could show that the injury or illness did not result from a work-related cause. And then work-related, we have definitions, and you can learn more about it. But the basic idea of work-related means it occurred on the employer's premises. It occurred as the result of work-related activities. The employer was required to be there by the employer. The employee was traveling to work or to a place he or she was required to be by the employer. And notably here, one thing that does not cover is just my normal commute to and from work. So if I'm just driving to work from my house or driving from work back to my house at the end of the workday, and I get in an accident, then that's not my employer's responsibility. That's just part of my normal commute, not covered. But in the other cases where I'm doing something that's required of my employer for me to be doing, probably covered. Intentional acts we also list as an exception to workers' comp damages restrictions. So if a workplace injury is caused by an employer's, so we're flipping the script here and saying if the employer was willful in whatever they did, so maybe they were aware of a danger and they willfully didn't do something about it, then the employer can sue for compensatory and punitive damages. So punitive damages generally aren't allowed in these types of cases. It's only in extreme cases where we find like willful or reckless or something else, some other act by the employer that the court says, well, we need to make an example of you to show other businesses that you can't be allowed to do this kind of thing. That's what punitive damages are. Compensatory damages just compensate you for whatever loss you've suffered and try to make you whole again and put you back into a place that either compensates for that injury or put you back into a place where it's as if the injury didn't happen. But punitive damages might be allowed if we find out that the employer was acting intentionally. We mentioned violence in the workplace. Over the years, we've had instances where people are getting in fights or bullying other people on the job, and injuries can result from that. So it's in the employer's interest to develop an anti-violence policy, perhaps including a zero-tolerance approach and a process for filing and investigating claims, and having a proper application of disciplinary actions if I find out that my employees are considering, planning, or actually engaging in violence in the workplace. So that's our summary of OSHA. We'll move on to ERISA here. Again, this passed in 1974. And so it sets standards for retirement plans and health plans that are in private industry to provide protection for individuals that are in these plans. And it was a response to fears that retirement money could be lost if workers lose their jobs prior to retirement or lose health care benefits if, for whatever reason. Health care and retirement are two major benefits that a lot of jobs offer, a lot of employers offer to try to entice good workers to come work for them. And the loss of either one of these can be devastating to an individual, their health, their finances. And so ERISA was set in place to try to provide some guidelines, some rules regarding these types of benefit plans. You can hear stories in the past of a company that had a person on as an employer for 20 years, 30 years, and the year before their retirement was set to vest, where they would actually get these benefits, they got fired for some mysterious reason and they lost everything. And that's, of course, a very tragic story. We want to try to avoid that. This is going to be enforced by the Department of Labor as well. It applies to welfare plans and retirement pension plans. Welfare plans, we say, are healthcare, vacation, unemployment, and other benefit programs. There's not, so the only one I see in there that's actually required would be unemployment. Other benefits like healthcare, vacation, sick time aren't necessarily required to be offered. But a lot of companies do, of course, because you're trying to, again, entice the best workers to come work for you that you can get. We saw this question I started teaching this class during the financial crisis back in like 08, 09, when there were a lot of questions about, well, companies are on the brink of going under, and one of the ways they were thinking of trying to save money was cutting healthcare benefits for employees that are retired. So then this question arises, can they legally do that? The answer that we arrived at was, unfortunately, it probably is allowed. They could change a plan from a date going forward, which can change your benefits going forward, but they can't go and change things retroactively into the past. Okay, so those are welfare plans. Retirement plans, there's two major categories of retirement plans, at least here in the United States, that private employers can offer. One is called a defined benefit plan. This is where the benefit is defined by an upfront formula. And I give an example, like if you work here for 30 years, once you retire after that 30-year period, then we'll give you half of your pre-retirement salary per year for the rest of your life. So that would be an example of a defined benefit program. And these used to be way more common. Now they're pretty rare to encounter, especially in the private workforce, just because companies view them as being incredibly expensive and difficult to manage, things like that. So most private employers have moved over to, now the defined benefit plans still do exist, but not in the numbers that they used to. Most employers have moved over into what we call defined contribution plans. So these are where the benefit that you get at retirement really depends on how much you and your employer contribute during your employment. So the most common version of a defined contribution plan is the 401k. We hear about this all the time. So it's really incumbent upon the employee to deposit money into that 401k account. And oftentimes the employer, not always, but often the employer will provide some type of matching program where for every dollar that you put into the 401k, we'll match that dollar for dollar up to, let's say, like 6% of your annual income or something like that. So both you and your employer are contributing to this account. And then how much money I have at retirement depends pretty much entirely on how much did I contribute during my employment and how did those investments perform in that account. And then the employer really has no responsibility to me after they've given their contribution. So ERISA imposes the following requirements on employers for these types of plans. The plan, both for healthcare plans and retirement plans, any benefit plan, it has to be in writing. It has to be communicated to all employees in language they understand within a specific period of time. Employees have to be notified when something about the plan changes. The assets of the plan should be held in trust. We're trying to get the money management part out of the hands of the employer to the extent that we can and put those assets in trust managed by somebody else. And that is to hopefully prevent employers from going and raiding these retirement funds if the business is starting to falter, thus robbing employees of their retirement. The plan must be for the exclusive benefit of employees and their beneficiaries. So an employer may have assets of the plan returned only after all plan liabilities have been satisfied. So this is not going to happen very often. But let's say an employer over contributes to the retirement plan and we've met all of our funding liabilities. All the retirees have been paid what they need to be paid. And the company says, well, we think we overpaid. We would like some of that money back. We have to demonstrate that all liabilities have been satisfied before the employer will be able to get any of their own contributions back. They're never going to be able to get the contributions that an employee made, but for the employer's own contributions, maybe they can get some back. We have to satisfy certain minimum participation, vesting, and distribution requirements. We'll talk about vesting more in just a little bit because it's pretty important. It may only be established and maintained by an employer, though funding may be from either the employee or the employer or both. There are also some reporting and disclosure requirements here. So the employer has to provide a summary plan description. This could also be provided by the company that's actually administering the plan. But it basically just identifies the main points of the plan that employees should be aware of, puts it in plain language. Again, we're trying to avoid legalese or overly technical words that most people wouldn't be able to understand. So things like, what is the name of the plan? What type of plan is it? Who is eligible to participate in the plan? Give us a description of the benefits and when participants have a right to those benefits. It probably isn't right away. You might have to work there for a certain period of time before you're eligible. You have to notify of provisions governing the termination of the plan. If the company was to choose to terminate, they would have to give you a certain amount of notice and, whatever the rules that are guiding that. And give a statement of rights under ERISA to the employees under this summary plan description. Now, in 2012, as part of the Affordable Care Act, we placed an additional responsibility on employers, and this covers healthcare plans exclusively, but we had to provide a summary of benefits and coverage, or an SBC. So this is a summary of key features of a healthcare plan, again, in plain language. So what are the covered benefits? What are the cost-sharing provisions? What are the coverage limitations? A lot of us who have been working in the professional world for a while are probably used to seeing these kind of things from the employer. Here's all the information you need to know about your healthcare plan. And it'll be stated in this uniform format prescribed by the Affordable Care Act, passed back under the Obama administration, to hopefully give me the information I need as an employee to make good decisions about what plan I want to choose, what are going to be the limits, how much do I have to pay for like a copay and stuff like that. The employer has to file an annual report with the Department of Labor. Another amendment to ERISA was under the Pension Protection Act, or PPA, of 2006. This is a response to Enron and WorldCom, where we saw really tragic situations of employees who maybe had worked for Enron for a long time. All of their retirement plan savings were in Enron stock. The company completely collapsed, so a lot of employees lost everything. Everything that they were counting on to provide for them in their retirement was just wiped out. So we tried to set a rule to prevent this from happening again, or at least provide employees more options. So if there are going to be blackout periods, a blackout period is where a company says you can't sell our stock during this period of time. And that was one thing that got employees during the Enron collapse, was that there was a blackout period. We found out that company managers were selling stock as fast as they could, but employees were not allowed to sell any of their stock as it was tumbling down. And so that really rubbed people the wrong way. So you have to be notified of the blackout period, and participants that choose to invest in a company's publicly traded stock must be allowed to diversify into something else. So here, into at least 3 other investment options, and be notified timely of those rights to diversify. So diversification is one of those cardinal rules of investing. You don't want to put all of your eggs into one basket, but have them diversified into multiple areas. So where if one thing collapses, you're not completely devastated. You're still okay because you have other investments. So that's the idea. Under ERISA, we have a fiduciary duty. So a fiduciary is someone who has discretionary authority over investment or management of plan assets on behalf of others. So we're taking this retirement money or this healthcare money, and it's going to somebody who has a fiduciary duty here. Now, this places certain responsibilities on them. The requirements, okay, we'll get into a few of them. Loyalty. We have to run the plan in the interest of participants and beneficiaries, not solely in the interest of the company. Exclusive purpose. We have to act for the exclusive purpose of providing benefits and paying plan expenses, not just denying people for illegitimate reasons. Prudence. Investing and managing assets as a reasonable professional engaging in this type of investment would. Diversification, we just talked about that, to minimize the risk of large and devastating losses. Compliance with plan documents. I have to follow the terms of the plan documents once those terms have been established. And we have to avoid conflicts of interest. So that's what a fiduciary is. They're supposed to be somebody who's acting in your interest as the employee, as the investor, rather than following their own selfish desires or the selfish desires of the company owners or whoever else might want to interfere in the decision making here. And if we find out that the fiduciary has violated this fiduciary duty, then we can take action against them. Okay, eligibility and vesting under ERISA. Okay. So there are some federal guidelines here, and then companies can choose to be more generous than the federal guidelines if they want, but they can't be less generous, the basic idea. Okay, so employees who are over 21 and who have worked for at least 1 year must be covered by an employer's pension plan, whatever plan we have set up. Vesting. Vesting is this process of acquiring rights that cannot be taken away. So what does this mean practically? Well, let's talk about 2 things. Employee contributions. Let's assume we're talking about a 401k plan here. So the money that I as an employee contribute is always mine. And I can always, at the end of employment, I can take that money, move it somewhere else to another 401k, withdraw it, whatever. It's always mine, 100% mine. But the money that the employer contributes on my behalf isn't always mine. It has to be vested over a period of time in a lot of cases. So there's a couple different ways that that money could become 100% mine as the employee. One of these ways is called cliff vesting. So after 3 years of employment, the employer contributions become 100% vested, and then they're mine as the employee. Or we have graduated vesting, meaning that we can gradually vest over the course of 6 years. So for the first year, 0% vested. In the second year, 20% vested. Third year, 40%. And so on till we get to 100% over the course of that 6 years. And then again, companies can be more generous than this as a way to try to entice people in. They just can't be less generous than what the federal guidelines are. So funding requirements under ERISA. For defined benefit programs, employers must adequately fund the program to keep up with accrued benefits. So the benefit manager has to be able to do some forecasting, some auditing to look at How much money is being brought into the plan? How much money are we paying out? How much do we anticipate we're going to have to pay out in the future? And we have to do some work to make sure that we're adequately funding the program to keep up with those accrued benefits. So this is one of those reasons why companies don't offer them anymore, because it can be hard to predict. It can be difficult to manage. It can be very, very expensive. And a lot of companies, we found out, weren't adequately funding, and then they had to make a large lump sum payment into this, dragging the business operations down because they were trying to fund retirement programs or other benefit programs. So then a lot of them have just moved over to 401ks and stuff just to make it easier on themselves and less expensive. We must also purchase insurance from the Pension Benefit Guarantee Corporation, PBGCs, federal entity that operates as an insurance plan for these type of benefit programs. If there's a devastating loss, if it's terminated with insufficient funds, it kind of operates like the FDIC for bank accounts. So if my bank closes, the FDIC covers my deposits. So sort of a similar idea here behind the Pension Benefit Guarantee Corporation. A couple other things we'll mention in here past that are sort of amend and then just add on to ERISA here. So COBRA, you may be familiar with this if you've quit a job or lost a job. It's called the Consolidated Omnibus Budget Reconciliation Act. Some big words thrown at you here. Passed in 1985. The idea behind this is that health coverage is incredibly important to people, especially if you have some health issues at play and you can't afford to go uninsured for really any period of time. And a lot of people, especially as you get older, find themselves in this situation where you just can't afford not to be covered by health insurance. So what this does is it gives the employee the right to continue health coverage, key point, at their own expense for a limited time after job loss. 18 months of coverage possible, but you would have to pay the entire premium. And you might be shocked to find out how much those healthcare premiums actually cost. If you quit or lose a job, and they'll send you a COBRA notification that says, hey, you can continue your health coverage. Here's how much it will cost you. And you might have a little bit of sticker shock if you have to find out how much your employer was paying for your health coverage. The last thing we'll talk about here is HIPAA, the Health Insurance Portability and Accountability Act. This amends ERISA to promote standardization and efficiency in the healthcare industry. Provides protection for employees and families with pre-existing medical conditions. Provides protection of individual privacy regarding healthcare data. A lot of people are very closely guarded about their healthcare information for good reason. You don't necessarily, if I have a lot of healthcare problems, I don't necessarily want people to know about that. I want that to be private information. I don't want it getting out. I especially don't want an employer to find out about it and then potentially discriminate against me because of that. Even though I'm protected under the ADA, things get really messy. So best case for me is that all my healthcare data is private to me and it doesn't get out there. And then in 2009, the HITECH Act was enacted to stimulate adoption of electronic healthcare records. And we're kind of all used to this now, that anytime we go to a doctor or a specialist or whatever it is, there will be an online portal you can log into that will contain all your healthcare records. If I go to a different doctor, I can request that all those records be sent from one place to the other without waiting on a very time-consuming paper document transfer process. Again, we kind of take this for granted now, but it took legislation to actually get the ball rolling and to get it enacted. That wraps us up for this lesson. I hope you all have a great day.